what the 7-year-old understands is what eluded Justice Holmes. But they don't understand what Rousseau said. The mere capacity to seize and hold power over others cannot itself establish the rightness of that rule. Now, Justice Holmes was asked, on what ground does the majority rule the minority? And the answer was, because the majority can overpower the minority, which is to say, the rule of the strong. What I'm saying is, any 7-year-old reacting to the stealing money grasp that point right away.
Right.
So getting back to your point, and you took as the point of entry, Eric, the plowman and the professor, what the ordinary person readily grasps. And sometimes what you find among lawyers is that they've needed a good deal of legal training to be tutored out of the things that the ordinary person readily grasps.
Who said there's some things so stupid that only an intellectual could believe them? Thank you, Hadley, for agreeing to participate in this. It's going to be a hard-hitting journalistic interview. Are you ready?
I just came in to read the meter. They asked me to stay around for
look, that's good enough.
All right,
okay,
go ahead.
As we will talk about in your book, in discussing your book, Mere Natural Law, Originalism and the Anchoring Truths of the Constitution. And in this book, oddly enough, when you talk about coming in to read the meter, because since you're a joker, nonetheless, there's something to that. Because in the book, part of the thesis of the book is the idea that people who come in to read the meter, you say the plowman.
Oh, that's so good. That is so good.
Quote unquote normal, unlettered people, nonetheless, have enough common sense to make moral decisions, and it's an extraordinary thesis. So why don't we start there with my asking you to lay out briefly the thesis of the book Mere Natural Law and why it's titled Mere Natural Law.
Well, we drew on the allusion to C.S. Lewis, the way he noticed that in the conversation among children, you'd see there's an argument about not likes and dislikes, but matters of right and wrong. And the assumption seems to be in play that there must be standards of judgment to tell the difference between right or wrong answers, and he assumes that each one assumes the other one knows it.
So children assume this. This is innate.
Yeah, no, this is...
So that's Lewis's point.
Right. What I want to do is take it to a dear friend of mine, late friend, Daniel Robinson, who lectured at Oxford, said he wanted on his tombstone, he died without a theory. And he was appealing to Thomas Reid, the great Scott philosopher, who's read by James Wilson and American founders, who was appealing to those precepts of common sense that the ordinary person has to grasp, the plowman and the man who reads the meter, the ordinary man has to grasp before he starts trafficking with theories. And so the sense would be that before the ordinary man would start bantering with David Hume about the meaning of causation, he knew his own active powers to cause his own acts to happen. Now, the American founders understood those things. They began with these precepts of common sense. They were the principles that were there and the truths that were there before the Constitution. And because they were there before the Constitution, they also realized they'd be there even if there were no Constitution. As John Quincy Adams said, that right to petition the government, they'll be there even if it hadn't been mentioned in the First Amendment. It'd be there even if there were no First Amendment.
Okay, so to bring it down...
Even if there were no Constitution, it would be there.
To make sure that I'm getting it, the idea of natural law is that, as you just said, whether there's a constitution or isn't a constitution,
right,
there is nonetheless this thing called natural law. There is right and wrong. There are rights given to us by God, whether we know it or not, whether our leaders acknowledge it or not. These things exist apart from this piece of paper called the Constitution.
Right.
And that, to me, having read almost the whole book, that's your fundamental thesis, that you're the gravamen. I've always wanted to use that word publicly. The gravamen of your thesis is the idea that those legal scholars who talk about originalism, that they're not going far enough. In other words, that they're talking about the Constitution, and you're saying there's something, even if the Constitution didn't exist, there are these truths that are implied in the Constitution, that are referred to in the Constitution. I mean, that's basically what you mean by natural law.
Right. Well, okay. The James Wilson, after we named this institute of ours, one of the premier minds among the founders, said, we didn't bring forth this Constitution or this government for the sake of inventing new rights, but to secure and enlarge those rights we already had by nature. So yes, the problem with originalism as we see it now is that these people detach the American founding from those anchoring principles that were there before the Constitution, the principles to which these people were persistently appealing as they sought to trace their judgments back to the anchoring ground of their judgments.
Okay, you taught law at Amherst for 50 years.
Well, not all the 50 years, but yeah.
Roughly speaking.
Right.
We have staff that will look into the details. But for roughly 50 years,
fact checker.
For 5 decades, you were at Amherst teaching this stuff. And in the course of your lifetime, which extends obviously beyond the time you were at Amherst, we've been living with this really very bad idea of a living constitution. In other words, we have Supreme Courts in the past that have effectively said we can read into the Constitution almost whatever we like. In reaction to that, I'm guessing, correct me if I'm wrong, in reaction to that fast and loose and sloppy and harmful view of the Constitution as whatever we want to read into it, there developed a school of thought called originalism, where people said, no, we've got to stick to the text as the founders meant it. In other words, if we're going to, the title of your book is Mere Natural Law, Originalism and the Anchoring Truths of the Constitution. I want to be clear on what originalism is before we get into how that's not quite enough. So is it safe to say that the living Constitution idea, I don't know if it's the Burger Court or whoever started effectively saying that, we're the Supreme Court and we can kind of pull whatever we want out of it, that's what led to this idea of originalism, or not quite?
Yes, the Warren Court and the Burger Court. And the conservatives recoiled, say, to the articulation of a right to abortion. They thought the vice was not that there was something wrong with not sustaining laws that restrained abortion, but that there was something wrong with the judges making up a new right. But the point was, if you think there was something specious about what they're saying, then the cure for that, the remedy, was to show what is specious about it. But rather what they did is take the line that it's dangerous whenever you move outside the strict text of the Constitution. My right to be presumed innocent until proven guilt, that's not in the Constitution. The founders didn't put in the Constitution everything they knew, and they're persistently appealing outside the text in making their own decisions, those anchoring truths that were there before the Constitution. So we have this curious situation which some cultivated men are telling us that there are no moral truths apart from what's in the text of the Constitution.
Okay, but that's in reaction, again, to the Warren and Burger Courts. Let's go back, just to set this up, to the Warren and Burger Courts and to the issue of the concept of the penumbra. Explain, if you would, to the plowman who will be listening, what is, the penumbra? Talk about that, because that's what obviously some of these legal voices were saying.
As President Nixon used to say, I'm glad you asked that question. What do we think the ordinary man would say if he were told that Jones, accused of a serious crime, was undergoing surgery at the time the crime was committed? Would anyone really doubt that any ordinary person, not burdened with theory, would say, why was he being prosecuted? The ordinary man would understand what Thomas Reid, Kant, Aquinas understood as the very first principle of all moral reasoning, is that moral judgment begins in the world of freedom, where people have the freedom to choose one course of action over another. We don't hold people blameworthy for acts they were powerless to effect. That is an anchoring axiom.
Okay, so everybody knows if the guy is under surgery, he doesn't even have the ability to commit a crime.
Right.
Okay.
And the ordinary man, I think, grasps that without the need for tutoring. And from that simple point, we can extract many other things that run through our law. Now, listen, of course, we have to deliberate at times on whether was Jones really incapacitated, was he under hypnosis, but those things are kind of contingent and variable. But the one thing that will never be contingent is the principle itself, that if Jones was incapable of affecting the outcome, he cannot be held blameworthy. Now, let's take just a second one, from going back to Lewis, the conversation of children. I offer this example. Let's say, imagine a 7-year-old who's set upon by roughnecks in school. They steal his lunch money. Now we ask, which of these two reactions you think would be the, quote, natural reaction? 1, he feels set upon, unjustly hurt and harmed. Or 2, the other side must have been right because they succeeded. I don't think anyone would credit the second one. The first one is the most natural one. But if that's the case, what the 7-year-old understands is what eluded Justice Holmes. They don't understand what Rousseau said. The mere capacity to seize and hold power over others cannot itself establish the rightness of that rule. Now, Justice Holmes was asked, on what ground does the majority rule the minority? And the answer was, because the majority can overpower the minority, which is to say, the rule of the strong. What I'm saying is, any 7-year-old reacting to the stealing money grasp that point right away.
Right.
So getting back to your point, you took as the point of entry, Eric, the plowman and the professor, what the ordinary person readily grasps. And sometimes what you find among lawyers is that they've needed a good deal of legal training to be tutored out of the things that the ordinary person readily grasps.
Who said there's some things so stupid that only an intellectual could believe them?
I think it was Orwell.
You think it was Orwell?
Yeah.
I'm pretty sure it was me. Actually, I got to correct myself.
I think Orwell got it.
No, I correct myself. It was I. No, but I mean, that's at the heart of this book. And I want people to understand that what you're saying is that just as in C.S. Lewis's book, Mere Christianity, Mere Natural Law, you're talking about what is the heart of the concept of our law as enshrined in our Constitution and our rights, and that there's something that precedes the words on the page. There's this fundamental thing.
Right.
But I still, in order to set up this conversation, I still want to go back to what led to this. In other words, we had in the 20th century, let's call them liberal justices in the Supreme Court who thought it was all right to play fast and loose with the Constitution and, in effect, to ignore the actual words and to say, well, we think that somewhere in the words of the Constitution, there's the suggestion of a woman's right to an abortion. And when pressed on that, they would say it's in the penumbra. In other words, it's as though the words are casting a shadow, and in that shadow, someplace we find the right to an abortion, which is not in the actual text. So is my understanding of that part of it roughly correct, so we can move forward?
Right, but what they thought they were doing is they probably didn't think they were inventing something. They thought they're probably drawing the implications that are already embedded there. Right. And what we'd say is that they've drawn them incorrectly. They've drawn them wrongly.
Okay, so
that is, it's hard to see how you get from the Equal Protection Clause or any liberty clause in the Constitution to the right to kill an innocent human being, if you're clear that it is a human being that you're dealing with. Or how do you get from the liberty clause to the autonomy and same-sex marriage. How do you find that implicit in that? It's going to take some work. It should take some work to give us the steps of reasoning that possibly lead out from autonomy to the notion that there's no ground of judgment for the way in which people act out their sexuality.
Well, it's a little bit like reading the Bible, right? Like there are people who can read anything into the Bible. And we would say, you're wrong. That's a misreading of the scripture. But they act like, no, I can read it the way I want. I have this this right to my subjective interpretation. And that's in effect what happens in the middle of the 20th century. You have a bunch of justices in the Supreme Court who somehow decide that I think abortion is a good thing, so I'm going to somehow, and we don't need to talk about abortion, but the point is it's the most dramatic example of what we're talking about, is that they look at this document of the Constitution, they say, someplace in here, even though it's not in the actual words, we're kind of finding what we want to find. And they rule, and Roe v. Wade becomes the law of the land. And in reaction to that, I would say a proper reaction, you have a number of legal minds that say, excuse me, that's out of bounds. What you're finding in this document isn't actually there. And so we need to go back to what's actually there. So that's called originalism. Yes?
Yeah, but their point is, if it's not in the Constitution, it's not mentioned, say the Constitution does not mention the word abortion, therefore a federal judge is not in a position to proclaim any rights springing from the Constitution. But of course, marriage wasn't in the Constitution when they struck down the laws that forbade marriage across racial lines. See, they sought a shorthand formula that if it's not in the text, then they can't reach it. Look, I think everyone seems to agree on all sides today. Remember that classic decision of sterilization in Virginia, Buck versus Bell, a woman thought to be slow was sterilized, and Justice Holmes said in that magic phrase, 3 generations of imbeciles are enough. Everyone takes that to be wrong. Let's say we did take that to be wrong. What right would you be invoking to protect Carrie Buck? Is there some right not to be sterilized? There's nothing in the Constitution about that. What you'd have to do is go back to the Due Process Clause, which is really carrier of all those principles that the founders didn't think to write down in the text. The Due Process Clause was the carrier. Look, George Sutherland, the great, for whom I wrote a book, he was a judge on this famous Scottsboro case of these black kids who, in the 30s, hopped a railroad train out of a railroad car, and they were in with some white girls. There's an accusation of rape. You had a trial in a hostile town. The kids were cut off from any source of support. They didn't know how to arrange a lawyer. Here's George Sutherland looking at this case. And he's saying, look, the casual way in which they went about this thing, it just doesn't satisfy the rudiments of what we call the rule of law. He strikes it down, but he did not, as they say today, incorporate in the Constitution the Sixth Amendment, to incorporate again, say, the Sixth Amendment with a right to a lawyer, I now am going to apply to the state. No, what he's telling us is this would be wrong even if there were no Sixth Amendment. And it would be wrong even if there were no Constitution. See, what I'm pointing to is, this is what's missing here, Eric. If the shorthand is, if it's not in the text, we have no ground to speak about it. But that can't make sense of so many other things we do and have done.
Well, obviously that's the point of the book, which is a remarkably readable book because, most of us who aren't legal theorists or were never law students, nonetheless, we care about these things, which kind of makes the larger point that we all care about these things, whether we know the terminology. Right. But I still want to establish, just for people who are listening to this conversation, that so there was a time when most people read the plain reading of the Constitution. Then you get, in the mid-20th century, you get these folks that play fast and loose with it and make some rulings, Roe v. Wade and others, that really almost seem to find what they want to find in the Constitution. And then there arises a school of thought, which we now call originalism, where you had a number of people, many of whom I know are your friends or were your friends, who said, wait a minute, you're playing fast and loose with the Constitution. There is no actual right to abortion or whatever in the Constitution. You're looking for it, you're finding what you want. That's not okay. So we now say we believe in this idea of originalism. And as we were saying, as I said a moment ago, a lot of these people would be your friends. In other words, these are the people that would be called, conservatives, roughly speaking.
Right.
But the point you're making in this book, which is a radical point, and it's why I'm belaboring it to some extent, I want people to understand, you're saying that the originalists, that school of thought, legal thought, they are making a fundamental mistake. And in some ways, ironically, it's similar to the mistake of the Warren and Burger courts on some level.
No, it's kind of it's like saying, you people are using moral reasoning not contained in the text. We'll show you. We'll forego moral reasoning altogether.
Okay.
That's our corrective to the problem. That's our corrective to the problem.
Okay. That's what I meant to say, is that, in other words, they overreacted to the error.
That's right.
And they said, you're finding things that ain't there, and so now we will only talk about what is clearly there. And what you're saying in this book is that once you do that, you've been lured into a trap, because now you're unable to do the moral reasoning that's necessary, because you're so focused on the text, that you're forgetting that the founders assumed many things that they didn't put in the text, which is what you've said.
But take it one step further. They think it's wrong to appeal outside the text to objective truths that are inescapable. Take, for example, the decision on transgenderism, where Anthony Stevens says if he claims to be a woman, the rest of us should be obliged to respect that judgment, or else put ourselves and our employers in trouble. And how does Neil Gorsuch get to this? He's trying to reason within the text of the Constitution, the Civil Rights Act of 1964, barring discrimination on the basis of sex. Now he's going to broaden it. But what he doesn't do is say, well, quite apart from what the dictionary said about sex in 1964, there is just the objective truth of what sex is, of why, in fact, we are constituted as males and females. I think the Congregation for the Doctrine of the Faith once said, there has not always been a Hungary or an Italy, but as long as there are human beings, there must be males and females. That is the telos, the very purpose of sexuality. Now, the curious thing is why, in fact, even in the case on the Dobbs case on abortion, we have 6 conservative judges who would not say that small being in the womb is a human being, or the standing of a human being. We've had, those judges in Texas in Roe versus Wade made the case to defend those laws on Texas. They drew the most updated embryology, woven with principle reasoning, to show that unborn child has never been anything less than human from its very first moments, and never really a part of the mother. The curious thing is why 6 conservatives will not make the same appeal.
Recently, in the Dobbs decision that overturned Roe v. Wade, they were being, and again, this is to me the key to this whole thing, they felt somehow handcuffed, like they could not go a millimeter beyond, quote unquote, the text. And it puts them in an odd position. So they can rule, they can effectively overturn Roe v. Wade, but they feel because the Constitution doesn't say that this is the killing of a human being, we can't mention that. You're saying they ought to have mentioned it. Why ought they to have mentioned it?